A growing wave of new legal requirements is landing on UK landlords over the next couple of years, and a significant share of landlords currently have no idea which of these documents they're actually missing until an inspection, a tenant complaint, or a tribunal dispute forces the issue to the surface. Missing even one of these can mean thousands of pounds in fines, an invalidated eviction notice, or in the worst cases, a landlord unable to legally regain possession of their own property at all. In the next few minutes, I'm going to walk you through 7 documents every UK landlord needs before 2027, exactly what each one covers and what happens if you're caught without it. Because unlike a lot of landlord compliance advice, every single one of these has a real, specific, and sometimes very expensive consequence attached to getting it wrong. I've been tracking the UK property market for years, and landlord compliance has quietly become one of the areas where the gap between what landlords assume they need and what they actually legally need has grown considerably wider. Let's get into it. Before running through the list itself, it's worth understanding why this particular moment matters more than most. Landlord compliance obligations in the UK have grown steadily over the past decade, but they've tended to arrive one requirement at a time, spaced out enough that most landlords could absorb each new obligation individually without feeling overwhelmed. What's different heading toward 2027 is the convergence of several separate compliance deadlines, tightening minimum efficiency standards, evolving tenancy reform, and increased local authority enforcement resources, all landing in roughly the same window. A landlord who's been managing the same property for a decade or more without regularly revisiting their compliance paperwork is considerably more likely to have at least one of these 7 documents quietly out of date than they might assume. Document 1. The current gas safety certificate. If your rental property has any gas appliances, a boiler, a gas cooker, a gas fire, you are legally required to have a gas-safe registered engineer inspect them annually and issue a valid certificate, which must be provided to tenants within 28 days of the inspection and to any new tenant before they move in. This isn't a document many landlords forget entirely. Most know it exists, but a significant number let it lapse by a matter of weeks or months, assuming a slightly late renewal is a minor administrative slip. It isn't. Local authorities can and do prosecute for gas safety failures, and in the most serious cases involving genuine harm, landlords have faced criminal prosecution, unlimited fines, and in extreme cases, imprisonment. Beyond the safety risk itself, a lapsed gas safety certificate can also directly undermine a landlord's ability to serve a valid Section 21 eviction notice, because certain prescribed information, including proof of a valid gas safety certificate, must have been provided to the tenant for that notice to be legally enforceable. There's a specific timing detail worth being precise about here. The requirement isn't simply that a certificate exists somewhere in the landlord's records, it's that the specific certificate covering the current inspection period was actually served to the tenant and served within the correct window relative to both the inspection date and the tenancy start date. Which means a landlord who has the physical certificate sitting in a filing cabinet but never actually sent a copy to their tenant is, in the eyes of the law, in exactly the same non-compliant position as a landlord who never had the inspection carried out at all. Document 2. The current energy performance certificate. Every rental property needs a valid EPC, typically lasting 10 years, showing the property's energy efficiency rating, and rental properties in England and Wales generally need to meet a minimum efficiency threshold to be lawfully let at all. Landlords letting a property below the minimum required rating without an appropriate exemption registered face financial penalties that can run into thousands of pounds per property. And crucially, an expired or missing EPC, much like the gas safety certificate, can also invalidate a Section 21 notice if it wasn't provided to the tenant as part of the required prescribed information at the start of the tenancy. With EPC requirements for rental properties expected to tighten further as the sector moves toward higher minimum standards, landlords with older properties sitting close to the current threshold should treat this document as something to actively monitor, not simply file away for a decade and forget about. It's also worth noting that certain older or listed properties may qualify for specific exemptions from the minimum standard, but these exemptions themselves need to be formally registered on the National Exemption Register. They don't apply automatically simply because a property has period features or structural constraints that make efficiency improvements difficult. And a landlord who assumes an exemption applies without having actually registered it is, in practice, treated as non-compliant regardless of how genuine their underlying justification might be. Document 3. The Electrical Installation Condition Report. Landlords in England are legally required to have the electrical installations in their rental property inspected and tested by a qualified person at least every 5 years, with the resulting report, the EICR, provided to tenants and on request to the local authority. This requirement is relatively newer than the gas safety obligation and catches out a meaningful number of landlords who assume, incorrectly, that because their property's wiring was checked once at some point in the past, or because the property is relatively modern, they're automatically compliant. They aren't. The 5-year inspection cycle applies regardless of the property's age or previous inspection history, and any remedial work identified in the report as required must be completed within a specified timeframe, typically 28 days, with confirmation provided to the tenant once done. Local authorities have specific enforcement powers for EICR non-compliance, including financial penalties that can be imposed per breach, and landlords who've never had this inspection carried out at all are, in the eyes of the law, currently operating a non-compliant tenancy, regardless of how good their intentions might be. What makes this particular document catch out landlords more than most is that unlike the annual gas safety certificate, which has been a well-established requirement for decades and is now deeply embedded in most landlords' routines, the 5-year EICR cycle is comparatively recent, which means a meaningful number of longer-standing landlords simply haven't yet incorporated it into their mental checklist of what being compliant actually requires, treating it as an optional extra rather than the mandatory recurring obligation it actually is. Document 4. The Deposit Protection Certificate and Prescribed Information. If you take a deposit from a tenant, and the overwhelming majority of landlords do, that deposit must be registered with a government-approved tenancy deposit protection scheme within 30 days of receipt, and the tenant must be provided with the prescribed information about which scheme is being used and how the deposit is protected. This is one of the most consequential documents on this entire list because failing to protect a deposit correctly or failing to serve the prescribed information within the required window doesn't just risk a fine, it can result in a court ordering the landlord to pay the tenant between 1 and 3 times the deposit amount as a penalty on top of returning the deposit itself. And critically, an unprotected deposit can also block a landlord from serving a valid Section 21 notice entirely, meaning a landlord who wants to reclaim possession of their own property may simply be unable to do so through the standard route until the deposit protection failure is remedied. There's a further complication worth naming specifically. Landlords who've had the same tenant for many years and who took the deposit before more recent legislative changes tightened the rules further sometimes assume that because the original protection was compliant at the time, nothing further is required. But renewed tenancy agreements, and in some cases changes to the tenancy terms themselves, can trigger fresh prescribed information requirements, meaning a deposit correctly protected a decade ago isn't automatically still fully compliant today, if the tenancy has since been renewed or its terms altered without the corresponding paperwork being refreshed. Document 5. The Current How to Rent Guide. This is the document most frequently overlooked because it seems on the surface like a minor formality rather than a genuine legal requirement. Landlords in England are required to provide tenants with the current version of the government's How to Rent Guide at the start of a tenancy and, crucially, whenever a new version is published, meaning a guide provided correctly 3 years ago may no longer satisfy the legal requirement today if the guide has since been updated and the tenant wasn't given the newer version at an appropriate point. Like several of the documents already covered, failing to provide the current How to Rent Guide can prevent a landlord from serving a valid Section 21 notice, which means a landlord could have done everything else correctly, gas safety, EICR, deposit protection, and still find their eviction notice thrown out purely because they handed over an outdated version of what many assume is just a general information leaflet. This document deserves particular attention precisely because it's so easy to dismiss as unimportant. Unlike a gas certificate or an EICR, which clearly relate to physical safety and therefore feel serious, the How to Rent Guide reads on its surface like a general consumer information booklet, and many landlords genuinely don't realize that providing an outdated version carries exactly the same legal consequence in terms of blocking a valid Section 21 notice as failing to protect a deposit or missing a gas safety check entirely. Document 6. The right to rent check documentation. Landlords in England are legally required to check that every tenant has the right to rent property in the UK before a tenancy begins, and to retain copies of the documents used to verify that right for the duration of the tenancy and for a specified period afterward. This isn't a one-time check that can be done casually and forgotten. Landlords must also be aware of specific rules around time-limited right to rent status, where a follow-up check is required at a later date for tenants without permanent residency status, and failing to conduct or properly document these checks can expose landlords to civil penalties that scale considerably depending on whether the failure is judged to be a first breach or a repeated one, and in the most serious cases involving knowing non-compliance, criminal liability. What makes this requirement particularly easy to get wrong is the retention obligation specifically. Landlords sometimes conduct the check correctly at the outset, verify the tenant's documents in good faith, but then fail to retain copies of what was checked for the required period, which means that if a dispute or an audit arises later, they have no way of actually demonstrating that the check was ever properly carried out in the first place, regardless of whether it genuinely was. Document 7. The current signed tenancy agreement itself, ideally reflecting any changes to the tenancy that have occurred since it was first signed. This sounds like the most obvious document on the list, and yet a meaningful number of landlords, particularly those who've had the same tenant in place for many years, are operating on a tenancy agreement that's badly out of date, doesn't reflect the current rent amount if it's been increased informally over time, or was drafted before recent legislative changes that affect what terms are actually enforceable. An outdated or poorly drafted tenancy agreement can create genuine ambiguity in a dispute, precisely the kind of ambiguity that favors whichever party has the better legal representation rather than whichever party is actually in the right. And with tenancy law continuing to evolve, particularly around the end of Section 21 covered in an earlier video on this channel, landlords should treat their tenancy agreement as a document to periodically review and update, not something signed once and filed away indefinitely. A particularly common gap here involves informal rent increases agreed verbally or by email over the years without a corresponding formal variation to the written tenancy agreement, which can create genuine confusion about what the actual legally binding rent figure is at any given point, especially in a dispute where the tenant and landlord recall the history of increases differently and neither has clear contemporaneous documentation to settle the question definitively. Now, here's what connects all 7 of these documents, and it's the part that catches out even genuinely well-intentioned landlords. Several of these requirements, the gas safety certificate, the EPC, the deposit protection prescribed information, and the current how to rent guide, don't just carry their own individual penalties for non-compliance, they also individually and cumulatively determine whether a landlord can legally serve a valid Section 21 notice at all. This means a landlord who is diligent about 4 out of 5 relevant documents but slips up on the 5th doesn't just face a partial compliance problem, they can find themselves entirely unable to reclaim possession of their own property through the standard legal route, regardless of how reasonable their reason for wanting the property back might be, until every single one of those prerequisite documents has been properly, currently, and correctly provided to the tenant. There's a specific practical implication worth drawing out clearly. This means the moment a landlord most needs to demonstrate full compliance, when they're actively trying to serve an eviction notice, whether due to rent arrears, property damage, or a genuine need to reclaim the property, is precisely the moment their compliance history gets scrutinized most closely, often by the tenant's own solicitor or a housing advice charity actively looking for exactly this kind of procedural gap to challenge the notice. Here's what nobody puts together properly. As Section 21 itself moves toward being phased out under wider tenancy reform, the specific documentation prerequisites tied to it become in one sense less immediately relevant to the eviction process itself, but the underlying compliance obligations, gas safety, EICR, deposit protection, right to rent checks, don't disappear alongside Section 21. They remain independently enforceable requirements with their own separate penalty structures, meaning landlords who assume that the end of no-fault eviction somehow reduces their overall paperwork burden are mistaken. If anything, the compliance landscape is becoming more document-heavy over time, not less, as each new piece of tenancy and safety legislation tends to introduce its own additional certification or documentation requirement rather than replacing an existing one. Here's how this plays out for landlords who haven't audited their paperwork properly. They discover a gap, an expired gas certificate, a missing EICR, an outdated how to rent guide, only at the worst possible moment when they're already trying to navigate a difficult tenancy situation, a rent arrears dispute, a problem tenant they need to remove, and the missing document becomes an additional, entirely avoidable obstacle layered on top of an already stressful situation, sometimes adding months of delay to a process that was already going to be difficult regardless. Here's how this plays out for landlords who conduct a proper compliance audit. They create a simple, dated checklist covering all 7 documents for each individual rental property they own, noting exactly when each one was last issued or provided and when it next needs renewing or reissuing. They set calendar reminders well in advance of each renewal date, rather than waiting for an expiry to catch them by surprise. They specifically check whether the How to Rent Guide version they provided at the start of the tenancy is still the current one, since this is the document most likely to have quietly gone out of date without any obvious trigger to prompt a landlord to check. And for longer-standing tenancies, they periodically review whether the original tenancy agreement still accurately reflects the current rent, the current legal landscape, and the current relationship with the tenant, rather than assuming a document signed years ago remains fit for purpose indefinitely.
Here's how this plays out at the wider level over the next couple of years. Expect continued tightening of EICR and EPC minimum standards as part of the broader push toward improving the quality and safety of the UK's rental housing stock, meaning documents that are currently compliant may need updating sooner than their nominal renewal date if the underlying standards themselves change. Expect increased local authority enforcement activity generally as councils face growing pressure to demonstrate they're actively protecting tenants, which in practice means landlords with any of these 7 documents missing or out of date face a rising, not falling likelihood of being caught. And expect the overall compliance burden on landlords to continue increasing rather than simplifying, which is itself a contributing factor to the landlord exodus covered in an earlier video on this channel, as some landlords, particularly those with just 1 or 2 properties, conclude that keeping pace with an expanding and increasingly document-heavy compliance regime is no longer worth the return, especially layered on top of the tax and mortgage pressures already covered elsewhere. There's a specific dynamic worth watching within this trend. As compliance becomes more demanding, expect a growing share of remaining landlords to shift towards using professional letting agents or property management companies specifically to handle this document burden, rather than self-managing, which itself changes the economics of being a landlord, since professional management fees eat further into the profit margin that's already been squeezed by the tax and interest rate pressures covered previously on this channel.
If you're a landlord, the single most valuable thing you can do this month is conduct a genuine document-by-document audit against this exact list for every property you own individually, rather than assuming your compliance position across your whole portfolio is uniform. Confirm your gas safety certificate is current and was properly served to your tenant within the required window. Check your EPC rating and its expiry date and confirm the property still meets the current minimum standard. Verify you have a valid EICR completed within the last 5 years with any required remedial work properly closed out and confirmed. Confirm your tenant's deposit is protected with an approved scheme and that the prescribed information was served correctly and on time. Check whether the How to Rent guide you provided is still the current version. Confirm your right to rent checks were properly conducted and documented, including any required follow-up checks for time-limited status, and review your tenancy agreement itself to make sure it still accurately reflects the current terms of the tenancy as it actually stands today. None of these 7 documents is individually complicated to obtain or maintain, and none of them requires specialist legal training to understand. What makes this list genuinely dangerous for landlords isn't complexity, it's the fact that each document has its own separate renewal cycle, its own separate consequence for non-compliance, and in several cases, a direct knock-on effect on a landlord's ability to legally manage their own property when it matters most. The landlords who avoid the worst outcomes described in this video aren't necessarily the ones with the fewest properties or the simplest tenancies. They're the ones who've built a genuine habit of checking this exact list methodically for every property on a regular schedule, rather than discovering the gaps only when a tribunal, a council inspector, or a difficult tenancy situation forces the issue. Building that habit doesn't require specialist software or expensive professional services. A simple spreadsheet with one row per property and one column per document, each with its last issued date and next due date clearly marked, is often entirely sufficient to transform this from a source of ongoing anxiety into a routine, manageable part of being a responsible landlord.